Good evening. Welcome everyone here tonight. I'm going to call to order the Board of Zoning Appeals meeting for February 24th, 2020. If I can get everyone to stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I'll ask for a quiet roll call.
Mr. Kennedy,
Here.
Mr. LaRue is absent, Mr. Popovich,
Here.
Mr. Sheeran,
Here.
Ms. Wooland,
Here.
Mr. Eberly,
Here.
Attorney Decker,
Here.
Mr. Panzik,
Here.
and we also have with us Councilman Blazak in the audience.
Next on the agenda is approval of minutes for December 23rd, 2019. If anyone had a chance to review and comment. If not, if everything looks good, gentlemen, I wasn't here, but I'll have to rely on Paul and you two, if you guys were here that day. If you agree with the minutes, then I'll vote as well.
I was absent.
Brendan? They look good? Okay. Then with that, I will take a motion to accept.
Second.
I need a motion.
I motion to.
I got a motion. Do I have a second?
Second that?
You can,
Yes.
even though you weren't here, you can accept the minutes. And what we could do is we can do a contingent on that, we're going on
Yeah.
on Paul and Brendan's comments that they were here.
I accept.
Okay, we got a second. Do you want to make the motion contingent on that? We're basing it on Paul and Brendan's review?
Yeah, I'll make the motion that it's contingent.
Or wait, Brendan, would you make that contingent your motion? My motion is that, because three of us weren't here
Okay, yeah. Contingent.
on just your review?
Yes.
Okay, we got a second?
I second.
All in favor? Aye.
Aye.
Opposed? Minutes carried. All right, next on the agenda is election of officers. Do I have a motion for chairperson?
I make a motion that Mark LaRue be chairperson.
Do I have a second?
I second it.
All in favor? Oh, discussion, none. All in favor, say aye. Aye. Opposed?
Who has the second on that, please?
Nancy. Do I have an appointment for vice chair?
I make a motion that John Kennedy be vice chair.
Thank you. Do I have a second?
I'll second it.
Discussion, all in favor, say aye.
Aye.
Opposed, no. Now, there's no secretary for the BZA, or is there just,
Just appointing a recording secretary,
okay.
yes, right.
Okay, do I have an appointment for recording secretary?
I make a motion to appoint Nancy.
Well, no,
No,
no.
this is
I'm sorry,
recording secretary.
this is recording
so
secretary.
It's
Oh, I'm
Margaret.
sorry.
Sorry, there is no secretary for this one.
No executive secretary.
No executive secretary.
Okay. I make a motion that Margaret and
Be recording secretary.
be recording secretary.
Do I have a second? Discussion, all in favor, say aye. Aye. Opposed? Motion carries. Congratulations, everyone. All right, next on the agenda, we have David Velasco, 8743 Mallard Lane. Petitioner is seeking a side yard setback for a fence that was built beyond the side yard building line. Is Mr. Velasco in the crowd?
Mr. Velasco is here, Mr. Chairman, for this meeting.
Yeah.
I'll set the stage for us. Mr. Velasco applied for a privacy fence to enclose essentially his backyard. If you look at your screens, and for those members of the audience, they can look at the large screen there on the east wall. The application showed the fence in the correct location. On a corner lot of on a corner setback, a fence cannot go beyond the corner side yard setback, building setback line without a variance. And the permit was filled out and shown that the fence would be constructed on that building line, that 20-foot side yard setback line over here. In reality, the contractor built it 10 feet further out than that. So the fence is now 10 feet off of this sidewalk where it's required to be 20 feet per the plat. That's the platted side yard setback for this corner lot. When I saw that fence put up in error, I contacted Mr. Velasco and indicated he had a couple of options. He could either replace the fence, have it put back to the proper setback line, or he could seek a variance. And I did advise him that if he could seek the variance, and if he gets turned down, he may still have to move the fence anyway. But he chose to seek the variance, and that's what, he is here tonight for that purpose. He has met all the conditions of conducting the public hearing. He's posted the notice in the newspaper. He's contacted by mail all the property owners within 300 feet of his property, and he has also posted a sign on the property advising people of the variance request. I have had a couple of people stop by the office who received the letters and/or who saw the sign, and they were inquiring what the variance was about, what the request was about, and when I explained it to them, they did not have a problem with the location of the fence. So I have no remonstrances opposing the location of the fence, either oral or written, in my office. With that, I would ask Mr. Velasco to step up to the podium here and take any questions that the Board of Zoning Appeals members might have. It is, by the way, a 6-foot privacy fence that he's had constructed. It's vinyl, correct, David?
Yes.
Yes.
Mr.
So-
Velasco, just for the record, can you just state your name and address, please?
David Velasco, 8743 Mallard Lane, St. John, Indiana, 46373.
Very good, thank you, sir. Any questions for the board, or Mr. Velasco, do you want to make any comments to the board?
I just had the contractor send me a letter stating his mistake in regards to posting the fence out further than allowed. And then also I just printed out pictures from the street side viewing part of the fence, just in case somebody wanted to take a look at the views or anything like that.
Can we
Sure, certainly.
keep a copy of that letter
Certainly.
for our record? And then second, Rick, should I read the letter for public record?
Sure. And hand it to Margaret if that's a copy, so Margaret can include it in the minutes.
This letter is from Fence Master. Mr. Velasco, I am writing this letter to address the matter regarding the fence and the required building line setback on the property. When I reviewed the plat of survey to properly address required codes, the property placement of the fence, I apparently misunderstood the building line setback. I thought we were in compliance because it was my understanding the building line setback was 20 feet from the house, not 20 feet from the street. My apologies. Please let me know if you have any questions or if I can be of any assistance in this matter. Thank you, David Aguilo, Residential Manager.
And Mr. Chairman, just to follow up on that, I had not seen the letter or heard of the letter until just now, but that the house is 30 feet setback off of its south property line or 30 feet back from the sidewalk. So I can understand if the gentleman thought he could build 20 feet out from the house, that would leave the fence 10 feet off of that south property line. So those measurements make sense given his misunderstanding of the setback regulations. But the setback, in fact, is 20 feet in this case from that south property line, not 20 feet from the house.
Were there plans for the, do you view plans, were there drawings for the fence where it would be located?
Yes.
And where did the fence show?
So the fence, this is the plans for, the plan that he created for the backyard.
So this drawing actually shows the fence 20 yards off the house. Okay. And have you talked to Fence Master regarding the potential if this does not pass variance?
Yes.
Have you talked to him?
Yes, I told him that I would attempt a variance, but if it does not get accepted, then they'll have to adjust the setback of the fence line.
And have they been agreeable to that?
It sounds like he's kind of have to agreeable to it because he said it incorrectly.
Okay.
Brendan has a copy of the survey that he's gonna be passing down to you, so you can see that by the X marks that the contractor put on that Plata survey, that shows where the fence was supposed to go, and in fact, it was built, as I said earlier, 10 feet too far to the south.
Rick, have we had any issues with Fence Master? Is this,
First issue with Fence Masters that we've had since I've been here,
Okay.
3 years.
and we usually have the setback, especially at a corner lot, for line of sight, correct?
Yes.
Okay.
And as you can see here from the Google Earth view, this is David's house here. The fence comes off that rear corner, right, David?
Correct,
Yeah, it
yes.
comes off here and then back to the backyard and encloses the entire backyard in this kind of a manner. So I have gone out there and looked at it myself, and from any approach, it does not cause a line of sight issue. You would think that the one most impact would be southbound traffic on Mallard looking easterly, and it simply just doesn't create a line of sight issue. If I measure that back from the front sidewalk to where the fence starts, it's
Oh, yeah.
80-plus feet.
Yeah, I drove it, there's no issue. I'm gonna bring it back to the board. Does anyone have any questions? Unless Dave, I apologize. If you have any more comments, if not, I'll ask the board if they have any questions for you or for, yeah.
Mr. Velasco, did you have, the Plata survey available during the time of the installation?
Yes, I gave the Plata survey to the contractor initially.
Okay. Were there any checks as far as like, the installation, and yeah, I'm noticing like, his draft shows a 20-foot, distance from the house versus the 30 feet?
Checks from me or checks from
Yeah,
him?
just in general.
So for me personally, the Plata survey is kind of a reference, but I got to be honest, I wasn't able to interpret every single meaning of the numbers around the survey, so I kind of trusted him with it.
Right.
And that's why I was caught off guard when I received the letter from the board stating that the fence was placed incorrectly.
Any more comments? There's no one that asked to speak on behalf of the public. David, I might ask you, is there anyone from the public that wants to speak on behalf of this? Either in favor or opposed? All right. I'll bring it back to the board for any comments, questions, or, again, this is not a recommendation. This will be approval. This variance will stay with the lot. It is not to the homeowner. So just understand that. Other
And
than
you
that-
do have copies of a copy of the Development Standards Findings of Fact in your packet. It might be on the bottom of your pile, but it's the Development Standards variance request. So if you're going to make a motion, you have the 3 criteria there to reference in your motion.
Just in my history with the BZA, we have allowed a lesser distance off the street for situations like this. I try to be sympathetic to the homeowner. Sometimes a screwdriver to me is vodka and orange juice. I am not technically savvy, when it comes to stuff like this, so I do heavily rely on the contractor to do their the work. And since Fence Master hasn't had a track record, I did look at it, I drove it twice, the site. I don't see a line of sight issue, no neighbors. I think if a neighbor came up and, you know, said something, I would have more pause or concern. But seems like neighbors have come in, have talked to Rick about it, have not expressed any concerns with it. So just my 2 cents, and again, it's a board decision.
I'm gonna go with no. I mean, the reliable contract you paid for messed up, period. I don't see a reason that this got done for some malady that you had. You know, we have a rule for a reason. He messed up, he should fix it. That's my opinion.
And that's a valid point. That's why I was,
I had to cut down foundations for an inch. But, you know, I mean, you didn't do it, it's not your fault, and I don't like to be the bad guy, but, you know, it's.
Brent, and you're not the bad guy. We're following our rules.
The
It-
rule's the rule. What's stopping the guy next door saying, okay, why can't I do it? Maybe he has a sort of variance issue. What's stopping the guy at kitty corner when that gets developed? I mean, why have the rules if we're just gonna say, oh, the guy screwed up, let's forget about it?
Mr. Velasco, do you have in writing from Fence Master that they will repay? Is
I don't
there
have it
anything-
in writing. It was essentially an email back and forth, and he didn't really
Okay.
say in writing that he would. I assume,
And moving the fence back to you, you do not have anything currently structured in the backyard that will be in conflict with the fence being pushed back?
no.
Okay.
And Rick, you said, as far as line of sight, you didn't see an issue with that?
No.
Mr. Chairman, if I may,
Absolutely, Paul.
Um,
Councilman.
just observing to the east is going to be a front yard adjacent to that side yard, so it becomes a little more relevant. Someone is going to or will be buying that lot, and that fence will be in their front yard by 10 more feet. Am I reading that correct, Rick? So the lot directly to the east is part of Walden Clearing? Where you're at?
No,
Yeah.
that's not Walden Clearing, that's Morning Crest. Let me take a
Or-
look at that, Paul, and make sure there's a platted.
Because that'll be a
lot there.
straight lot, across the street will be a corner lot, but
Oh, I see what you're saying. So the driveway will be coming off that, potentially off that road.
yes.
Okay.
Retention pond. Are you talking directly in back of the yard?
Right.
Yeah, that's a retention pond. Oh, yes, sir.
I find it difficult to understand how a contractor couldn't read that plat. I'd looked at it myself. It's 20-foot building line. It doesn't say 20 foot from the building. And signatures like that on a blueprint are typical. 20-foot building line is pretty well known. It's 20 foot from the property line. And you could tell it's 2/3 of the way between the sidewalk and the house. So I'm not sure how they dropped it in the wrong spot. It doesn't give dimensions from anything with that 20 foot. It just says 20-foot building line. And anybody who's had any experience,
They have it in this drawing, in this sketch. They have 20 feet coming off the house, south. Then they have a gate.
Legally, that doesn't make sense doing it where the house is when you draw something like that. You gotta go off your building set line,
Okay.
and the property line.
You're good.
Right. So
That's
here's
fine.
the plat.
Houses should make no difference.
Here's the plat, and what the gentleman said is correct. Lot 72 is David's lot, and then immediately east of him is Outlot B, a drainage and utility detention facility. The first house isn't until over here, so it's a couple hundred feet away from from David's fence. So David's fence would be adjacent to this Outlot B.
Thank you, Rick.
Yeah, I tried to come down to street level view, but none of this is here. When you get to street level view, it's all open field. There's nothing here. So you wouldn't be able to get an idea from this level, but so you go back to the aerial, and again, that fence is probably right, I'm sorry, it starts here, comes out here, 20 feet from the house, and then back to this back property line.
Board, we have comments and suggestions. If we need a motion, we could approve, deny, defer, depending on the board. But I mean, Brendan makes some valid points. I think the last time we gave a variance is because it tied up with a backdoor neighbor, the fence variance on a corner lot, because the neighbor to the backside had the
That-
same fence. And I
That
think
was in Silverleaf.
yeah,
yes.
we allowed them to go to a 3-foot because it tied into a fence in the backyard. It was only 3 feet and we allowed that. Other than that, but again, Brendan, I mean, it's a valid point. The contractor's at fault. And just as presiding chair, I cannot make a motion, so.
That's a tough one, I mean, as far as,
No, I mean, it's great to have Brendan up here. He's a contractor. He understands it a lot better than I do. And he's right. You know, we have rules for a reason. I try to be, I rely too heavily on contractors sometime, but I think a good contractor, if fence master is a good contractor, they will move it back if it's,
right, yeah, I agree with that. I'll make a motion to deny the variance.
When we make a motion, you have to refer the finding of facts. If you would please read out the 3. It is, so you gotta read each one of these.
Okay.
So in approval will not, sometimes a lot of people say the strict interpretations will not result in practical difficulties in the reason why you are denying it. So you could say it will, and it will not result in strict. And turn your microphone on, please.
All right, so I just want to make a motion to deny the approval, that the approval will not, or, I mean, will not be injurious to public health,
It won't-
safety, morals, comfort, or general welfare of the community, that the use and value of the area adjacent to the property included in the variance, well, in this case, it would be
you could-
affected.
you could.
In a substantially adverse manner. The strict application of the terms of the zoning ordinance will result in
No, will not.
will not result in practical difficulties in the use of the property.
It's just saying if we make him push the fence back, he
Right.
still has use of his property.
Right, yes, okay, I got it. While it doesn't seem that it would obstruct, like, view, I just think about, like, kids going to school and people driving fast, and I would rather have that option of more visibility, the better, in terms of just safety of the public.
So I have a motion to deny. Do I have a second? I have a second. Discussion? All in favor, say aye. Aye. Opposed? Motion carries. Mr. Velasco, hopefully Fence Master will honor their word and moving that fence back. Thank you.
So, Mr. Chairman, were the first two findings that were those will? The first two findings, approval? I know the third one was will not. I didn't hear what the first two.
Yeah, will. And then the last one is will not. So I
Okay,
think he put will not.
okay. Got it. Now, and when David and I discussed this as a possibility, he did ask about a time period for the fence to be placed in its legal position. And I indicated that given the weather conditions, I would certainly be inclined to give him to sometime in March to make that correction.
Brendan, as a contractor, do you get a time frame for this, like 3 months, 6 months?
No, yeah, you gotta be reasonable, yeah.
Because of concrete, he's gotta, I bet those footings aren't concrete, so
They're busy, we don't,
Yeah.
yeah, of course, I would give them 3 months,
3 months? I'm fine with that.
So
within the next 3 months.
I-
2 months.
if
Okay.
you're fine with that, I just thought, I thought at least 60 days to give him time, but yeah, that's fine. Yeah.
We'll give him 3 months. Okay.
Okay. So we'll say, May, by Memorial Day,
Okay. Thank you.
okay?
Next on the agenda, we got Jake and Kelly Green at 9303 West 94 Court. Petitioner is also seeking a side yard setback to build a fence beyond the side yard. Rick, if you want to give us, make sure all the documents were in place and a
Yes.
breakdown for the board.
Sure. All items are in order for this petitioner to seek this request. Their house is, and you'll see this in a moment when I bring their house up. It is angled on their property, and they're asking for a variance to come out with I believe theirs too is a privacy fence towards their side property line, but let me get to it here so that we can. This is in Renaissance, Unit 1. Yeah, right here, okay. And you can see how their house is addressed over here on 94th Court. They have a 30-foot building line, whether it's on 94th Court or on Renaissance Drive, it's 30 feet. And they're proposing to come out to some distance, which they need to specify. On the drawing that I have, it just shows it close to the sidewalk, but it doesn't give me an exact dimension as to where that is. So they'll have to explain how far they would like to come out towards that sidewalk. But again, excuse me, this is the property here, and they're looking to come out towards this sidewalk here. Their front yard setback is here because they're addressed on the court. This is their side yard over here. So, and again, all items are in order for this petitioner to proceed with their request.
Jack and Kelly Green in the? You want to come up and present to the board? And if you just give your name, it's redundant, but if you can give your name and address again.
Jacob and Kelly Green, 9303 West 94th Court.
Thank you. And if you could just give a brief description of what you're requesting the variance to the board for?
Our building line is about 30 feet off from the sidewalk. So from that side, let me see here.
From that side, we were hoping to go back and meet up with our neighbors behind us, their fence. We just want to meet up along that. We have a big willow tree in our yard as well. We have 2 young children and 2 dogs that we'd like to be able to utilize our yard.
And that the fence would come off in parallel with the front of the house and be about, I think the neighbor behind us, it's like 2 feet off the sidewalk. So it'd be a straight shot to the sidewalk and then back to his.
There's the plat there on the screen, and they show it coming off from the front edge of their house towards the sidewalk, and then down here and enclosing the rest of the yard. All of this is legal, but the building line is right here, so any portion of the fence beyond here needs a variance. And as I said, there's no dimension here, so I'm not sure what this is supposed to be, how far off of this property line or that sidewalk that distance is supposed to be.
I would say it's about 2 feet. I don't know what code is for.
Well,
Or if
code is this building line.
Okay.
That's why you're here. You're seeking a variance because you wanna cross this building line here with the fence. So, anything beyond that is up to the BZA to either approve or deny.
So your neighbor to the south, I believe, if I can say that correctly, is 2 feet off the sidewalk?
I believe so.
Yes.
2 to 3 feet.
And we can take a look at that, right here, yeah. Talking about this fence here. Now, that's of course, a rear yard fence for this person, which, I don't know how long they've been here, but their fence goes beyond their side building yard, so whether they got a variance, I didn't look at that to see when, when they may have gotten a variance for this. Or it's possible they put the fence up when this regulation wasn't into place as well, so not sure about that, but
And
their
how-
fence already comes out there.
And what do you estimate that tree off the sidewalk?
I would say about 10 feet.
'Cause 2 feet, Paul, I'm going to you, in your years, I've been on 4 or 5 years, I don't remember anything lower than, that would be the lowest. I can see what they're saying with the tree, I get that. Trying to keep that tree within inside their backyard.
I've been-
2 feet is pretty tight.
Going back to January 1st, 2014, we've never approved a fence anything close to that, being that close to a sidewalk. I don't recall ever approving anything that close. I'm not
3 feet,
sure, our zoning ordinance was updated in '09, I think,
09.
We did,
and I don't know the age of that house. I was actually just logging into GIS to check that.
I know we did 3 feet to tie
3
up with an
feet. You've done
existing
3
neighbor.
feet before.
Maybe there was been we might have done 3 feet. It was probably a very unique circumstance.
Brendan, off a tree, understanding, follow the rules, trying to keep a tree within a backyard, how far would you keep a fence off a tree line?
Well, I mean,
If,
See the tree, the trip line of the tree, the root system of the tree goes out, equal to the trip line of the tree. You try and keep it off. You don't want to dig anywhere too much into that trip line, which is how far the leaves go out if you drew a straight line down. Then you could damage the roots. This is a little harder one than the last one, just because, they cut the fence back like they supposed to. It'll look silly with this fence here. It's a little different situation. That's not a huge tree, so it's not, but I imagine you definitely would like it in your yard.
I would really love the tree in our yard.
It has
Our
grown
daughter
quite a
loves
bit
it,
since
yeah.
then, since when this was recorded. But even aesthetically, from where the building line is and shooting back from our house, it look a little odd.
And you're trying to do a fence like your neighbors?
Yeah, well, I mean,
That small, like that?
whatever we could be approved for, we'll go
We
for.
would like a 6-foot privacy.
Yeah. As long as I can keep my kids safe and my dog safe, that's all we're worried about.
That plat.
Okay.
I'd like to see that picture again of the neighbors. too.
From the aerial, Nancy?
Yes, please.
Okay. There's the neighbor's fence there,
Yeah,
and their property is here. They're asking to come off of this corner in this direction to within some distance of this sidewalk, and then and go back here and meet this fence
Right.
at whatever dimension that is off of their sidewalk. Correct? Is that correct?
Yes.
Jacob? Yeah.
So that river birch would not be in the backyard. That river birch is in the, would still be in the front yard, correct?
Technically, yeah, with the front yard, yeah.
Okay.
So Brendan, you wanted to see the plat again, correct?
Yeah, so I know what they're trying to do, come this way.
Mhm.
The house behind it, I mean, aesthetically, that makes sense. I'm trying to force them to, come here and down here. But, they obviously, they don't wanna lose that tree, I understand that.
In the picture that we had of the two houses together, I think they both were, like, maybe they got approval or variance, the neighbor's house, but also the house over to the, what would it be, east? When we saw both of those pictures together, both of the fences looked to be kind of similar off the building line.
So this is where you get into people asking for these things, and someone said yes to them, and someone behind them comes up and makes much more sense, but because someone already said yes previously, well, they probably should have said no.
Oh, to the owner,
Yeah.
our neighbor?
And I learned the hard way, just because it was done in the past doesn't mean we have to do it now. And
That's
2
what I mean,
feet, 2 feet is way too tight
And I
for
agree
me.
with that, I'm just saying, like, now I'm looking at it from driving by there, does it look sillier to make them do it the way they should do it? Or let them try and match up with the neighbor? That's.
2 feet
that's-
is tight. Yeah, I see
that's where I-
aesthetically, I'm very
it's-
symmetrical,
it's
but
more the
that's
aesthetic symmetric that I'm looking at now. than the technical rules.
versus
what he has now.
I'm kind of a
Good
stickler
point,
for,
Drago.
if we have a rule, let's
I
stick
agree.
with it, but,
It's a big difference.
I'm not
That's-
opposed to not doing a privacy as well, if whatever would be
I think
okay
I would
with you
definitely
guys.
say no to the privacy, because that's a
That's
whole
fine
different-
with us.
That's a different ballpark altogether.
I would say you come 2 feet off the drip line and that's about it. But that tree grows. I know a tree grows every year. We gotta figure out a,
So instead of bringing it 2 feet in, you're looking more like to bring it 10 feet in, just butt in perpendicular to the fence itself.
push it back as far as we can. I don't know who would make that decision and determine that 2 feet is tight. So do you go, I don't know how far that tree is. Try to keep the tree in the yard, but give it enough growth and you don't destroy the fence in 10, 20 years when the tree grows even more. Is there an opportunity to defer, and I don't know what your time frame is. I know you got kids and you wanna go defer it, come back with a number of square feet that we could have someone review and say, based on this would be a good spot for it, but pushing it back.
Well, let me
I'd-
tell you this, if it helps at all with your decision-making, a fence like this that the neighbor has, this is actually allowed in a front yard. Because it's 4 feet or less in height, and it has at least 50%, it's what's called an open fence. It has at least 50% of its surface that you can see through. So you could have a fence like this in their front yard. They're asking for it in their side yard. So if that helps you with your decision-making, I don't know, but that's,
So that's kind of what I was getting at, not the 6-foot privacy fence, but something like this is is the way I would
yeah, so
definitely
what,
consider improving that.
so what I'm saying.
If you did a 6-foot privacy fence and did it that way, 2 feet.
Yeah, it looks
The answer would be no,
strange.
flat out with me.
Yeah,
My concern,
What I'm
Brendan,
saying is
is,
this fence here like this could be up here in this front yard, all the way up, not the side yard, but it could come off of
The old
here.
Americana white picket fence.
And,
Yeah.
yeah, right, the white picket fence concept.
and not that I'm saying the Greens are ever gonna move out of town,
Yeah.
but in 10 years, they can move out, and the next owner could put up a 6-foot privacy fence, and they have the variance, because the variance goes with the property.
Well, but you can put a condition that
Oh,
it
can you
not
put-
be.
Yeah,
Oh,
yeah.
we can figure that out.
Oh, yeah, I mean, if you're gonna allow it, you just say that it's gotta be an open fence. Or it's limited to 4 feet, and it can't, I would, I mean, if you're of a mind to approve it, I would, make it fit the definition of an open fence in our ordinance, which means, 50, at least 50% of the face has to be able to be seen through, and then restrict the height to 4 feet
And
if
those
you want to do
spigots are
that.
still less than 3 inches or 3 inches, so you
Yeah,
don't have to worry
it's
about the
good.
kids or anything.
Right.
Depending on how small your
Right.
dogs are, but you don't have to worry about the kids.
We've got labs.
Right. So the, Mr. Chairman, the board can stipulate any number of conditions that it may want to impose as a contingent or in with the approval of the variance. And so, you know, if it makes the findings a fact and the, you know, the 3 items, the findings that would allow for approval of the variance, it can also impose those conditions as part of that approval.
And actually, and I apologize, Mr. Chairman, I'm reading this, and I'm gonna ask Adam to look at this. I should have looked at it earlier, but this is the type of an open, these are the fence heights allowed in each district as follows. Open fences are allowed in a side yard. So this fence here is legal, because it's an open fence and it's allowed in a side and rear yard. It's also,
Well, it's, what I'm reading, Rick, is, and again, this is,
Just a distance off the, it's a side yard setback, which is the only
Site.
thing then.
right, landscaping and section,
it's in chapter
screening,
13.
chapter 13, section F5. Fences and heights are allowed in each district as follows. Open fences located in residence districts not more than 6 feet, and then it followed by.
In the
yes,
side, in the
side-
side and rear.
side
and
rear.
is Up here.
Residence districts not more than 4 feet in the front.
So as long as it's an open fence, like this, it's allowed. What they wanted to do was a privacy fence, that's why they had to seek
So if
that.
they agree to an open fence, we have no problems here.
Yeah, even with height, they can go 6 feet, as long as it's
We
an
don't
open
even-
You
fence.
should, I think you should match the neighbors, but I can't tell you what you can or can't do, but
Do you, is that the way you read that?
if this is an open fence to match your neighbors.
That's what's
you're-
allowed.
We're okay.
Sounds like, I'll let the lawyer tell you, but it sounds like we have nothing to say about it.
But that's not necessarily the setback. They're still the same.
It's allowed in the side yard,
It is, but,
what it's saying.
right, but it still requires, I mean, we're
Oh,
still.
yeah, I'm sorry, yes, because it does specifically say interior side yards.
That's
Up
not,
here.
it shouldn't, it should
Up
still
here,
be a side
yeah.
yard.
Denotes, right, S denotes interior side yards. F denotes front yards and side yards adjoining streets.
So if it's adjoining the street, it is limited to the 4 feet in
Which,
height.
which it is in this case, so.
Yes, so it would have to be an open fence and no more than 4 feet tall to be where they want to put it. They would not be able to put a privacy fence there.
So
And they would not need a variance then?
4-foot open fence, they don't even need a variance.
Correct.
And that,
No,
believe-
don't they need a variance from the setback, from
The building line?
the bill, or? Is. If it's interior side yard, there's still or is there not still the requirement for the?
No, and let me go to this, so, to try to make it clear. Oops, was it, here it is, okay. There is no setback for an interior side yard for a fence. A fence can go right over, since this is its interior, the fence can go right over to that property line. Because remember, this house is addressed on this street up here.
Right, so that would be considered
This is the front yard.
front yard, right?
Yeah, so there is no setback for interior side yard setback for a fence at all. It can go right to this property line, it can go all the way to the rear property line. Where it had an issue was on a corner lot, it could not go across the side yard, or the building line, which is what, in this case, it's a 30-foot building line. But that's a solid fence. This is an open fence. So an open fence located in a residential district is allowed in a side and rear yard of up to 6 feet in height, in a front yard and/or a corner side yard up to 4 feet.
Right, but when you indicated this, that's the front yard
Right,
setback?
that's
This is
front
the
yard.
side yard
This is
setback.
side yard, yes.
So what you're suggesting is this, they could build that fence here?
As long as it's 4 feet?
No, but without seeking the variance.
So what I'm saying is that they're allowed in this, beyond this line, if it's, in this case, an open fence and not more than 4 feet in height, without a variance.
Don't
Okay.
they have to be at the rear of the house, Rick? Don't they have to be in the south corner
No.
to be considered a rear? No? Okay, it's, okay.
No, it's confusing because the front yard, again, in the ordinance that Adam and I are looking at, F, the letter F denotes a front yard and side yards adjoining streets. So it treats a front yard and a side yard on a corner lot as being the same. It goes on to say that the fence and heights are allowed in each district as follows. And it says for open fences located in a residential district, not more than 4 feet in height in a front or side yard, as I'm reading that. Do you think there's still an issue with the setback? Because this is the front yard here, up here, and over here is the side yard.
So, Mr. Everly, as you stated, fences aren't even allowed in the front yard. So the way the zoning ordinance is written is it now allows it because of the height and the openness in the front yard and side yard. So it seems to then purposely omit the building setback line.
If it, as long as it's no more than 4 feet tall.
Correct.
And it's an open fence.
Meeting that standard that's actually specified in the zoning ordinance. I think that's why it's in there, is for the very reason you're mentioning.
Right,
Yep,
right.
makes sense.
That's the way I am,
The American white picket fence.
yeah.
Mhm.
Yeah.
So I guess the question is, do you want a privacy fence or do you want a 4-foot picket fence?
Whatever you'll let us have.
Well, right now, you wouldn't need our approval, from what I'm understanding, and Rick, and let me know if I'm speaking incorrectly. If you put a 4-foot open fence, like your neighbor has shown,
Okay.
you would not need a variance from this board. You could
Correct.
just put it in.
As
If
long as
you
it's
want
got the
a-
open slash.
Just like your neighbor.
Match
Okay.
neighbor's fence.
If you want a
Okay.
privacy fence, 6 foot where no one can see, and then we would have to, this board would have to decide.
You
Your
wouldn't be
side-
able to do a privacy fence of any height
No.
beyond the building, beyond the side building line.
And to be honest about it, I for one would have voted it down and it was taking it down, coming back.
Right.
So on the west side, we can do a privacy against the
You're not
neighbors.
gonna-
I
Yeah,
guess-
yes.
Yeah.
Yeah.
And not on the street side.
West side and even all the way over to your 30-foot building line over here, along the backyard, you could do a privacy fence if you wanted to.
Okay.
But from that 30-foot from, and I know it's hard to see, but from this point towards the street, it has to be the 4-foot open fence.
And we just saved you a couple grand.
Sounds good. Yeah.
And it
Yeah,
has
that's
to, it has to be 4 feet, not 6 feet.
4 feet or less.
4 feet or less, okay.
Yes, 4 feet or less.
Which their neighbor is probably 4 feet.
Yeah,
Looks like
Yeah,
that.
he is.
yeah.
Sounds good to us.
Thank you, guys.
Well, it's your decision.
Yeah, we'll do the 4 foot.
All right.
Okay,
Absolutely.
then
Well-
that needs nothing more than a building permit.
Okay.
What do we need to do for any procedural on this? Do we have to do anything?
No, well, I don't think there's a variance that's being,
So we'll just move on?
granted
Okay.
this evening. Now, again,
Nice to meet you.
yeah, and then the compliance would be through their permit that they're
Right.
going to seek from the
Right,
town to
right.
ensure that they're doing what they're saying they're going to do, so. I think you can move on.
We'll move on.
All right.
You have a great evening.
Thank you, council.
Next on the agenda, we have a training session on the agenda. And if I'm turning it over to Rick or to Councilman,
I've got some materials and Adam does as well. Are you handing yours out, Adam, or no?
Well,
How did you wanna do that?
if I hand my materials out now, will you be reading mine while Rick is presenting his? I can do that.
I've already heard Rick, so give me yours now.
Yes, he has.
Okay, I will hand these out, and then I'll let Rick start, and Rick, just
Yes.
since Mr. Velasco is still in the room, if he wanted to put a 4-foot open fence, he can go all the way to the,
He can go all the way to the sidewalk,
okay.
yes.
I remember his property line's a foot in the sidewalk anyways, he's only going 2 foot. You know, the pin's probably a foot in that sidewalk anyways.
It should be right at the sidewalk, yeah.
Yeah. I'd say 90% of the chance he's gonna match the neighbor.
Yeah.
He's silly to make that job, you know?
Okay. This is the BZA training session. We did do this last year, so let's see, Brendan, Drago, and John, you've been through this before, or were you guys on here?
I was- yeah, I was
You
here.
were on? Okay. Again, like I did with the Plan Commission, I'm not gonna go into the Indiana codes specifically, but just so you know, Indiana Code 36-7-4-900 through 999 is the section of the state planning law that deals with boards of zoning appeals in our state. For our purposes, we're comprised of 5 members. There is no political affiliation you have to be concerned with on the Board of Zoning Appeals like there is with some boards and commissions. 2 of the members of the BZA also serve on the Plan Commission. That is by state law. That's one of the few exceptions that allows a board member to be a member of more than one board. One of those members is appointed to the BZA by the Plan Commission. The other is appointed to the BZA from the Plan Commission by the council. Any decisions you make have to be a majority of the membership, not the majority of those present. So if you happen to have only 3 of you here, it's not 2 out of 3 wins. It's gotta be at least 3 votes, one way or another, to
3
take
votes.
action. So it's a majority of the commission membership. You have a set of the rules and regulations in front of you. We adopted those, amended those in April of 2017. And that shows you what a petitioner has to do, what they go through to prepare for a meeting like this. This is important, and I've mentioned it before at BZA meetings and Plan Commission meetings both. It's important that you understand that a petitioner has a right to ask for whatever they want to ask for. Oftentimes that upsets the public who's sitting here thinking, why in the world are we even entertaining some of the requests that we've had before us? But they have a right. But it's equally important for you to know that you don't have any obligation to approve or grant what they're asking for. I will say with the exception of a special exception. If, in the case of a special exception, if they meet the conditions of the special exception, then you don't have, discretion, essentially.
correct.
And one of the reasons for that is, we'll touch on it a little bit later, is the list of criteria by which you judge a special exception is created locally. They're not statutory provisions like some of the others are. They're locally defined criteria by which you decide a special exception. So if somebody's meeting those conditions and you deny it, you've got some issues there.
Potentially.
Potentially, yes. You conduct your public hearings on development standards, use variances, special exceptions, appeals of decisions made by administrative officials, all related to the regulations in the zoning ordinance. Of those 4 matters, the BZA has exclusive jurisdiction over development standards and appeals of administrative decisions. The use variances and the special exceptions are matters that you make recommendations on to the town council. They make the final decision. We are still one of only 2 counties in Indiana that applies to, us in St. Joe. In all the other counties in Indiana, the BZAs have exclusive jurisdiction over all matters that it conducts. It conducts public hearings on. Development standards variances, you had 2 examples of them here. It's a setback variance, it's a building height, it's building size, materials, things like those are development standards variances. A use variance would be considered, in this example, for a C3 use that somebody wants to conduct in a C2 zoning district. That would be a use variance. That's very similar at the plan commission level to a rezoning. It actually acts the same way. A rezoning is heard by the plan commission, made a recommendation to the town council, and the council makes the final decision in that case. For you, it's a use variance that you conduct a public hearing on and make a recommendation one way or the other. Your options, by the way, are favorable recommendation, unfavorable recommendation, or no recommendation to the town council. And then the council's free to do what it wants with your recommendation. As I said a minute ago, a special exception, that's a use listed in a given zoning district in the zoning ordinance that must meet certain criteria prior to being able to be operated. In chapter 3 of our zoning ordinance, there's a list of uses for each zoning district, and within those uses would be identified, those uses that need a special exception are identified in that list of uses. So it's pretty evident what needs to seek a special exception when the use is proposed, and somebody comes to my office and proposes a use for a zoning district. I look at that chart to make sure it's allowed where they want to use it, or does it require a variance, use variance or special exception, and then advise the petitioner accordingly. And then administrative, we haven't done, in the 30 years I've been doing this, I've never had an appeal from an administrative decision. So they're, I think, rare. I don't know, Adam, if you ever encountered them in your previous municipal experience, but I've not encountered one. Paul, did you say, were you on the BZA also in Cherville, or just playing?
Just plan commission,
Plan
but I've
commission,
not
okay.
heard of an appeal either.
Okay. I think those appeals from administrative decisions are pretty rare.
I
I've just
agree.
never seen one.
I agree.
Once you certify your recommendation to, on either of those, a special exception or use variance to the council, they have 90 days to act on the matter. If they don't, then it's approved, regardless of your recommendation. You might have issued an unfavorable recommendation to the council, but if they don't act on it within 90 days, it's approved by state law. And then I just go through some scenarios. Adam, is there anything you want to address before I get into scenarios? Any of the materials that you?
Well, yes, Rick, I think it might be a good opportunity. So, and tonight was a good example of this. The first request this evening for the variance from the development standards, think of it this way. If the board finds, and I'm going to use the sheet as an example, finds, and it really must find all 3 of these items that are listed, for example, that the approval will not be injurious to public health, safety, morals, comfort, or general welfare of the community. The use and value of the area adjacent to the property included in the variance will not be affected in a substantially adverse manner. And the district application of the terms of the zoning ordinance will result in practical difficulties in the use of the property. So those are the 3 findings that the board must make when it approves a variance from the development standards. It's possible for the board to perhaps find that 2 of them are met, but the 3rd one isn't. You have to find all 3 in your findings to approve the variance of use or from the development standards.
Right.
So I know there was some discussion about, well, what exactly were the findings when it was denied? You don't have to make any findings if you're going to deny a petition. You can simply say, we find that the standards haven't been met. So I don't know that you need to go through the recitation. Exactly, because I think that created some confusion about what exactly, and in my view, if you deny the petition, you don't have to make specific findings to support your denial of that petition. You only need to make those findings if you're going to approve a variance from the development standards or for a special use.
Interesting. But if you chose to reference those findings, Adam, in a denial, I believe it's true, I know Paul and John and I've experienced this, any one of those three findings could result in a denial.
Correct. So you have to find all three in support of the request in order to approve the request. If any one of them you find that doesn't meet that standard, you must deny it.
That, yes, right. So they could all be,
Yeah.
any one of which can result in a denial, but.
Right, so
that's-
for example,
Mhm.
and again, I don't want to belabor the point, but, and I'm trying to think of an example that this would be applicable for, but, and some of these are difficult to really understand, like the item number 3, that strict application of the terms of the zoning ordinance will result in practical difficulties in the use of the property. What does practical difficulties mean? Well, there, in the materials that I handed out, there's some examples of what some other communities and municipalities have looked at in defining that term, practical difficulties. And some of those communities may focus on, for example, whether or not it was self-imposed, whether or not the practical difficulty will deprive the owner of some use or economic use of the property, which really doesn't apply in a residential standpoint, but might with commercial or industrial applications. But I guess the point is you have to find all three of those items in your findings to approve a variance of the development standards. And for a variance of use, it's 5 criteria. So if you look at the form for a variance of use, you'll find that there are actually 5 criteria that must be met. So there's actually 2 more criteria than what we were talking about with variance from the development standards. So I know that I've thrown a lot out there, with the term variance and the variance of use and variance of development standards, but the point being, you have to find affirmatively all of the criteria before you can approve a variance.
So just to clarify, denial, you do not have to, because that has been that's what we've always.
In every case, we have always cited the findings of fact. Denial or approval, we've always cited the findings of fact.
Yeah.
No.
Do you mind if I ask Mr. Decker? We have cited it every time, including tonight. So, like, if I were to personally judge that fence, that third one is where I was hung up. Therefore, it wouldn't be approved. The strict application did not in any way make the property unusable. So we've always read it anyhow. And does that help to cover the town from any challenges to do so?
Well, that's difficult to say. I think that after thorough consideration and discussion, if that is the consensus, I don't know, obviously there's going to be a vote taken on a motion, whether it's to approve, in which case the findings must be found. If it's to deny, I have no objection and see no reason to be concerned if that member, as part of the motion, perhaps says, I find that, I move not to approve this petition, and I find that strict application of the terms of the zoning ordinance will not result in practical difficulties to the use of the property. That's acceptable. I think you could make that finding as part of the motion and wouldn't be a problem. I don't think it requires you go through all 3 of those items, because remember, if you find any one of them hasn't been met, that gives you the grounds to, and really requires you to deny the request.
Great. And I'll say this just for the benefit of the board. I'll wait till Mr. Kennedy, and you could share with us if you'd like. So, yeah, if any one of those three conditions aren't met in the finding of fact, it should be a denial. So, I'd like to back up a step and just kind of reinforce what Rick was saying about, there's three things you're gonna see. One of them is a variance, like tonight, the development variance. That's 90% of the work you're gonna be doing here is development variances. They're very common. The other two, the use variance, which is a certain kind of business, or a special exception, which is usually also a certain kind of business or building, are very rare, okay? But development variances are very common. And I'll throw a few examples, because Adam was digging for an example of a variance that you might approve because the strict application is an issue. A good example of that would be, we have some lots in town that are smaller, they're legal non-conforming, so we need a 2-acre lot to build a new business on. Culver's was only a 1-acre lot. So they said, here, we have an acre, we want to build a business, but we can't because we need this variance. So then we looked at the strict application would in fact make that land unusable. We have the same situation at 93rd and 41. So those are some instances where the strict application will make the property unusable to some extent, so we try to find a way to make it usable. So, Adam, I'm not sure if you caught that. I was talking about smaller lots than are allowed in our zoning. So it's legal non-conforming to our zoning ordinance, so folks have to come in here for a variance just to be able to even use the property. So we do see those occasionally where they have a lot size that's smaller than required, or they'll look for some grace on the building setback line or a buffer for landscaping, things like that, to be able to have more usable property. And then it's up to you all to just use those three standards. So, development standards are going to be something you're going to see a lot. They come in here a lot for signs. So that's another one where they'll come in here and say, we want a sign, a bigger sign than normal. And you have to ask yourself, well, if I don't give them the bigger sign, is the property still usable? Is it going to be a hardship? Are they going to not be able to sell their product because they're conforming to our sign ordinance? So I was always a real stickler for the sign ordinance because I think it's good. I think it's appropriate. I don't think more is required than that. But you're going to get your door knocked on quite a bit for extra signage. So that's just something else to be prepared for. It's something to be expected. And then also the fences. So it's a real common thing. Sometimes it makes sense for certain reasons, and sometimes it doesn't. There's no such thing as setting precedent. I know everyone worries about that, but on the BZA, you're a judicial body, essentially, a quasi-judicial functioning board, and you're making a decision one by one by one. So you can make a different decision on two similar cases because there's different things happening for each one too. So I will turn it back to Rick. Thanks, Rick.
Anything else that you wanted to add?
I might have something to add, but go
Okay.
ahead and you can go forward.
Okay, well, this is the end of the meeting, I guess.
Oh, that seemed to me.
This is the first scenario. The Sally Johnson has applied for development standards variance in order to build an oversized garage on her property. She placed the proper notice in the newspaper, filed her application in a timely manner, and paid the application fee. At the meeting, it's discovered that she did not mail the notices out to adjacent property owners. Can the public hearing proceed? The answer is no, because she did not meet the, one of those criteria of the public hearing. Notice to adjacent property owners must have been mailed in a timely manner. Same applies to the Plan Commission for public hearings. Now, in reality, I'm gonna know that ahead of time because they have to turn this paperwork in to me in a certain, 7 days in advance of the meeting. But you could, and we'll have another one come up here in a moment, but you could have a situation like this, and the answer is no. They do have to do, by our rules, and you'll see that's why I gave you the rules and regulations there, we require a 15-day advance notice. They have to put legal notice in 2 newspapers, the Times and the Post-Tribune specifically. At least 15 days prior to the public hearing, they have to mail the letters to adjacent property owners at least 15 days in advance of the meeting, and the sign has to be posted on their property at least 15 days prior to the meeting, and that's where the state law provides that that notice must be at least 10 days in advance of public hearings. Currently, we require 15 days. And municipalities are granted that authority to be more restrictive than state law. Again, 2 newspapers, Times and the Post, and we provide these notices for them. They're fill-in-the-blank notices that we provide to these petitioners. The property owners' lists are pretty easy to get, pretty painless. They're free, for one thing. If they're in St. John Township, they go to St. John Township Assessor's Office, give them their address, tell them they need a 300-foot search, and the assessor's office gives them that list within a day or 2, and there's no charge. If they happen to be in Hanover Township, in some cases, the St. John Township Assessor will still provide the list, but if I know they're in Hanover Township, I will advise them to go to the Lake County Auditor's Office to get this same information. And again, it's free from them as well. And the sign, we prepare the sign for them. Public Works Department prepares the sign. The petitioner has to pick it up from Public Works and put it up on their property. And then the next day, Public Works goes out and picks up the signs and brings them back. The cost, I always advise a BZA petitioner that it could easily cost them $500. The fee to come before you is $75. The 2 notices in the paper are gonna cost around $150 each. And then depending on how many letters they have to send out, those letters are about $7 a pop. So they could have $500 plus going out, and they could still get turned down, as in the case of Mr. Velasco. So I always advise BZA petitioners that they run that risk, and that just because they're asking doesn't mean they're gonna get the approval. Okay, if an adjacent property owner appears at a meeting and declares that they did not receive proper notice of the hearing, and it is discovered that they are not on the list of property owners provided to the petitioner by a source approved to provide such lists, does this invalidate the hearing? And my counsel has always been, and Adam can add to this if he'd like, that no, that does not invalidate the hearing, because for one thing, it's the fact that the person is at the meeting is presumed to be evidence that they did receive notice of some sort about the meeting. Additionally, the petitioner is not held responsible for mistakes made by the, in this case, let's say the St. John Township Assessor's Office. If they inadvertently leave a name off the list, the petitioner is not held responsible for that any more than the petitioner would be held responsible if the post office failed to deliver one of the letters to, and Adam, do you have any, you concur with that?
Yeah,
or-
no, I do. I generally do. I think that's correct interpretation.
Okay. Can the BZA make its decision recommendation conditioned on approval being granted to the specific petitioner and not to the property in general? And Mr. Kennedy made this point earlier, that the answer to that is no. You're making a decision based on the property, not who owns it, not if it's your buddy or somebody you don't like. You're considering the conditions relative to that property, because that variance is granted in perpetuity, goes with the land. So you just need to try as best as you can, and the smaller the community, the harder it is to do that. You just try to ignore who's asking for it and just consider the conditions that you are to consider in making your decisions.
So if there is a petitioner and you know them personally, do you ask to?
You don't recuse yourself, Nancy, only if there's,
Well, so, I'll address that. So, in section 909, and I'm gonna turn to that,
of the state law
of the
he's
state
referring to.
statute, yeah, let me turn to that. A member of a Board of Zoning Appeals is disqualified and may not participate in a hearing or decision of that board concerning a zoning matter if the member, one, is biased or prejudiced or otherwise unable to be impartial, or has a direct or indirect financial interest in the outcome of the hearing or the decision. So those are the two criteria.
Okay,
Mr. Eberly,
yes.
do you mind if I interject another example to this specific slide? This is one we encountered late last year. And you're granting it to the property and not the person up there, and it's really important. We had a situation last year where a property owner was improving a somewhat blighted home and garage, a property, which was a great thing. So we really wanted to make it work for them. So they had a garage that was beyond the building line. It was like 2 feet from the property line, which is completely non-conforming. So they wanted to connect the house to the garage, and to do so, they would need that variance to allow it to be 2 feet from the property line. But we had the issue we had was that if we were to improve that, someone could come tomorrow, knock the house down, and build an entire house 2 foot from the property line, because we're approving it to the property. So when we move a property line or move a line for a fence like tonight, it's forever. If you were to approve that, it could be any compliant fence at any time going forward. So it's really important to separate the property from the actual petitioner and what they're trying to do, because you have to think ahead for, if you approve this, what else could somebody do in 10 years, 30 years, and so on?
Right, thank you, Mr. Francis. We referenced this earlier, there are 3 statutory conditions that must be considered in a development standards variance, and what that means is that those conditions are set out in state law. And you went through those. These are the 3 that are relative to a development standards variance. There are 5 statutory conditions to consider in a use variance. Those are those, and you have a copy of these, so I'll just go through this quickly. But you have a copy of each of the findings of facts in your packets there. True or false, there are no statutory conditions to consider in making a recommendation on a special exception request. That is true. Brendan's correct, because the special exception criteria are what the towns, the individual municipality, are allowed to establish their own. In our case, we've established 7 criteria. They're on your findings of fact, and you'll also find them in our zoning ordinance at section 8, the section listed there. Right. And again, as Adam said, if you're going to find affirmatively for the request, you would have to find that all 7 are met?
Well, yes, I believe that it requires you to find affirmatively all 7 criterion in approving the special exception, yes.
And again, any one of which doesn't meet the criteria is grounds for denial.
Denial, right.
Yes.
Yeah. And I'm gonna add, I wanna make another comment about that, but I don't wanna interrupt at this time.
Can the BZA grant or recommend approval for a use variance for a use that is specifically prohibited in a given zoning district? Now, Adam and I have not had a chance to discuss this. In previous municipal attorneys have advised me that the answer to that is no. Most recently, I was advised by another municipal attorney that the answer to that is yes. So, I guess my answer is yes, because that's been my most recent counsel, but Adam and I have not had a chance to talk about that. Have you ever, I know this is off the top of your head,
It
so.
is, so you're proposing a use that's specifically prohibited in the zoning classification, or the zoning
Right.
district.
Right.
Yeah, my opinion is, off the top of my head, that the board, the BZA, can make that recommendation if they're, and provide some basis for why it's making that recommendation. And again, because it's a recommendation to the town council, ultimately, the town council would have to act on that. Now, the next question is, if it's prohibited, if the recommendation is made and it's prohibited, and the council takes no action after 90 days, then presumably that prohibited use would be,
Prohibited.
It
Approved,
would be
yes.
approved.
It would be approved, yes, yeah, yeah,
so,
yeah.
so, again, I haven't, that's off the top of my head, but again, it's a recommendation. It's nothing more than that. If there are reasons to justify that recommendation, as I suspect there would be, I mean, this is a pretty unusual circumstance that Rick's describing. I think it could make that recommendation.
But we have many prohibited uses in our zoning ordinance. In chapter 3 of our zoning ordinance, it has a list of allowed uses, prohibited uses, and special exceptions. And again, I've heard it both ways, so we're going with yes. State law requires that interested parties be given notice of a public hearing before the BZA. Who determines who interested parties are and how they are notified? That answer is that the municipality can do that. You can determine, we use the 300-foot rule, like I mentioned earlier. You have to notify people by letter, within 300 feet of the property. You could make that 100 feet, you could make that 1,000 feet. That's up to us. And we can decide whether they need to advertise in 1 newspaper or 5 newspapers. We choose 2. We also choose to make them put up a sign on their property. That's not required in state law. They just have to have notice, and we're allowed to decide who interested parties are and how they're noticed. Can BZA members discuss a pending agenda item outside of the confines of the actual meeting? That answer is only with BZA staff, Adam, myself. You can't discuss those matters with the particular petitioner or the general public. That's referred to as ex parte communication and is prohibited by state law.
That's correct. That's included in the materials I gave. There's a section on that.
Can the BZA impose reasonable conditions on the approval of a special exception? The answer is yes, per that code. Same thing applies to reasonable conditions for the use variance request. Now, I don't believe reasonable is defined anywhere in the law, but
Great catch on that one, Brendan. I didn't realize we could do that on that fence.
conditions, yeah. And the same thing applies to development standards variances. Yeah,
Well, could we do a privacy fence of 4 feet and allow that?
no, because of, well, I mean, you could grant the variance.
You can grant the variance.
Yeah, right, yes. Can the town council change, add to, or delete the reasonable conditions that the BZA attached to a recommendation? And that I double-checked with Adam too, because I've heard that both ways, and I think you agree that yes, the council can do that.
Yes.
Yes. All right, next scenario, Henry, did you want to, anything before I go into this one, Adam? Did you want to add anything?
Well, sure. I actually want to go back. I said something earlier in hindsight that, and this was about the findings of fact and how findings would be made if you ultimately deny a request for a variance. And I think I probably said it a bit too flip in the sense that I didn't want to suggest that no findings would be really acceptable, because from a legal defensibility standpoint, anybody who wanted to challenge the board's decision, even in that may be a denial, could do so on the basis that the board had not made, specific findings to support its decision. And I want to point you to page 32. So this is the handout I gave you. And there's a really good discussion about that on page 32. And it's the second paragraph. It says, in effect, the board must add a because to each criterion with a corresponding explanation. For example, the approval will not be injurious to the public health, safety, morals, and general welfare of the community because. So this is actually suggesting that you can't just simply rely on these general statements. For example, a variance from the development standards and the 3 criterion that are used. If you find that it's not met, it actually may be very good in terms of defending the decision to actually state why it doesn't meet that criterion. And that obviously requires you to know the facts, to listen, to give some reasonable consideration to the reason why it isn't acceptable. Now, that one example, for example, that Paul referred to, the third item, that the strict application of the terms of the zoning ordinance will or will not result in practical difficulties in the use of the property. If that was the finding of the board, it should say perhaps why, the strict application of the terms would not result in any practical difficulties. And if they can still build a fence, like in that example, if the contractor has already agreed or indicated that they're going to move the fence, then it's very difficult for the owner to say, well, that's a practical difficulty. I'm gonna have to spend thousands of dollars more to move the fence if that becomes, if the variance isn't approved. Just some examples of that. And there's also case law that suggests that you don't have to necessarily make those findings orally on the record. You can do it as part of a written record. And so if you decide to include your findings in a written record, you can do it at that meeting, and you can also do it at the next meeting if necessary. So it doesn't have to be at the same meeting where those findings are determined by the board, so.
Yeah, I'm glad you made that point, Adam. And John started down this path earlier in the discussion when he started to say we could defer this matter. You don't have to make the decision on the night that it's presented. When I first got here, in my opinion, there were, and Paul was experiencing this, I think, as a member of the BZA, where there were a lot of continuances from month to month to month to month. And you don't want to drag things out. But if you're not comfortable that you don't have enough information tonight to vote on something, you can always defer it to the next meeting. You don't have to make the decision tonight. We try to do that to be expedient, but I know, I think it was Levin Tire, Paul, if memory serves, that went on for a long time. Yeah,
Lucky Brothers took a few meetings as well. There was a lot of details to work out.
yeah. And I think that's what Brendan was talking about just a minute ago. So, you don't want to drag it out unnecessarily, certainly. But part of, in my opinion, part of my job is properly preparing any petitioner, whether it's for the Plan Commission or BZA, to be as prepared as they can to give you enough information so that you can make a decision this evening. Nobody wants to come back another month, especially if we've got a room full of people here that are upset. Now they've got to come back next month to remonstrate against whatever it is that's being proposed. So we've become much more efficient, I think, but I don't want you to think that you can never defer a matter to the next month if you feel like there's more information that could be valuable in helping you make your decision or your recommendation.
I agree. And one other thing I wanted to add, the burden is placed on the petitioner. So think of it this way. Status quo, they're asking for something different. They're asking to change the status quo. So they, the petitioner, have the burden to come forward with evidence to support your decision if a variance is going to be granted. In cases where, these are, tonight was probably an example of what is common, where it's just an owner or, that simply want to have a approval of a fence that was not located in the correct position. One of the thoughts and one of the comments made was that had the fence been left where it's at, which violates the zoning ordinance, it may have interfered with line of sight in the future. There was some question about that. Ordinarily, it would be the burden on the homeowner to perhaps come with evidence as to why it wouldn't be injurious to the public if it was left in place. And so that gets into some details, like if it's a commercial or industrial developer and they're seeking a significant variance from the development standards, they will probably come perhaps with an engineer or some other, an appraiser, to testify as to the fact that it won't be injurious to values in the, adjacent property owners. And they have to come forward and present that evidence to persuade you and meet their burden that, there will not be any injurious effects as a result of the variance from the development standards. So if they don't do that, if they don't come forward with that, then it's, you don't have to justify a denial necessarily. If they haven't met their burden, you can simply say, and in the findings, I would suggest, is to say, well, we don't believe that you've presented sufficient evidence, or you have not persuaded us that the variance will not be injurious to public safety or health. So just keep that in mind too. It's the burden on the petitioner to present that and the evidence that would support that decision, so. That's it, let's go ahead.
Okay. Adam, while I'm going through this next part, I'm going to ask you to look at something in relation to the structure of the BZA, because John mentioned earlier that we didn't have appointment of an executive secretary on the agenda for tonight, but when you look at the findings of fact, they're supposed to be signed by the president and the secretary of the BZA, so that would not be Margaret as recording secretary, so we should elect an executive secretary.
I'll make a motion
which-
for Nancy to be secretary.
I'll second the motion.
Discussion. All in favor? Aye.
All right, so we're still in the meeting, so we can do that.
We are.
All right, so,
You got off the hook.
so that was,
Actually, I cannot make a motion.
well, you're not chairman anymore.
I'm
You-
fine, so I'm moderating the meeting.
Oh, okay, if you want, you want to let Drago do it?
All right, I make a motion that Nancy be secretary.
I'll second it.
Discussion. All in favor? Aye.
All right, and you would sign this, John, you would sign the findings of fact for tonight, and as acting chair, and Nancy, you would sign as well. I'm sorry, I'm glad we caught that. Anyway, scenario number 2, Henry Ford appears before the board to petition for permission to build an auto sales lot at the northeast corner of West 85th Avenue and US 41. Property is Zone C3 and is also located in the US 41 overlay district. The C3 zoning allows for auto sales, what's called by right, which means they're just allowed in the C3 zoning district. However, since that land is also in the overlay district, which requires such use to seek a special exception, I'm sorry, I really read that poorly, but the overlay district requires that use to seek a special exception, so, when there's a conflict like that, the petitioner would have to seek a special exception. They'd have to, both districts, the 41 overlay district and the C3 district, would have to allow it in order for it to be a by right use. And we have a lot of uses like that that are a conflict because the 41 overlay district may not allow it and the underlying zoning district may allow it. So if one or the other doesn't, then you have to seek in this case, a special exception. Go back to what authority does the BZA have in hearing a request for a special exception? Is it the power to grant or deny the request, power to make a recommendation to the town council on the request, or no authority at all? Recommendation. Yep. Match the statutory findings with a particular variance request. I'm just gonna go to the next slide and show you that it was none of the above, because remember, special exception is not a statutory finding, it's a local finding, so it's kind of a trick question there. Who has the final authority in a special exception? Yes, as one of 5, he does.
1 of 5.
Town council.
20%.
Yeah, town council has the ultimate authority over a special exception. Third scenario, Stardust Corporation wishes to open a bowling alley on Alcott Avenue in an area zoned R2 Single Family Residential. Bowling alley is not an allowed use in R2, so what type of variance would they be requesting? That would be a use variance, correct? When a use is either not listed as an allowable use or is listed as a prohibited use in a given zoning district, then the use variance would need to be granted before the use could locate in such a zoning district. And that's an absurd and extreme example of what I was talking about earlier. A petitioner has a right to ask. There's no way that would ever be granted, but they have the right to ask. I should mention also, they can ask as the owner of the property, or they can ask as a petitioner with the owner's permission. And in that case, if they're not the owner, they need to provide a power of attorney, advising us that the owner has given them the right to seek whatever the variance is. Yeah, oftentimes, yeah. Now, if, and Adam, you might want to comment on this, but if oftentimes someone will hire like an engineer to represent them at the meeting, but the owner's also here at the meeting. So the engineer does not need a power of attorney in that case because the owner is present during the presentation. They're just, or they might have an attorney represent them. But if the owner's here, I've never required the power of attorney. Any thoughts on that?
You know, we can discuss that. I know what you mean, and I think generally speaking, an engineer or an attorney at law can represent a petitioner before the board without having a power of attorney document executed by the owner. But for purposes of, well, we can discuss that.
Okay. A common example of that, and Paul and John have seen this with Gates of St. John, for example, at the Plan Commission level. We know that Turinga is Lawton's engineer, and it's always Turinga that's making the presentation. 95% of the time, one of the Lawtons is here in attendance, but there may be the odd occasion where they're not able to be here, but I don't get a power of attorney from them in that case because I know he's their representative. Again, typically a power of attorney form would be required when the person making the presentation is not the person that owns the property. What statutory conditions does the request have to satisfy in order for the BZA to grant approval? Again, this is a use variance. The answer to that was all of the above. And I'll go through that quickly because you have the findings of fact there in front of you to show what findings you need to consider in each of those situations. Who has the final authority in a use variance matter? And that's Town Council. Fourth scenario, Jane Doe wishes to build a room addition onto the side of her house. She's located in an R1 zoning district. The room addition would be built to within 8 feet of the side property line. The minimum side yard setback requirement in an R1 zoning district is 10 feet. What type of variance is she requesting? Is it Did I hear an answer? She's seeking a side yard setback variance, which is what was being sought tonight. So what kind of variance was she seeking? It's a development standards variance. Setback is a development standards variance. And again, what statutory conditions does the request have to satisfy in order for the BZA to grant the approval? Check all that apply. You've got the list in front of you, so I won't make you do that, but it's those three. Oftentimes, hardship and practical difficulty get used the same way, but the law is actually different. There's a practical difficulty standard for development standards and hardship for use variance, I believe it is. But we kind of talk about them as one and the same, but just so you know, the statute uses the term practical difficulty for one of the three criteria of the development standards.
Right. That's development standards. yes.
Right, development standards. Again, who has the final authority in development standards variances? And that is the BZA. That is, if you just keep in mind that the only thing that you have complete authority over are development standards variances. Anything to interject before I go on?
No.
Okay. Scenario number 5, John Doe wishes to develop a warehouse on property that's zoned C2. The proposed use is not allowed in C2, but is allowed in the industrial zoning district. The lot is 14,000 square feet in size. The minimum lot size in a C2 zoning district is 32,000 square feet. The building will encroach on both the front and the rear yard setback areas. It will also be 5 stories high, for a total of 55 feet in height, and the maximum building height in a C2 zoning district is 50 feet. What type of variances will he need? Check all that apply. So in this case, the use is not allowed in C2, so he's gonna need a use variance. The lot is too small, so that's a development standards variance. The minimum, the building will encroach on both the front and rear yard setback areas, another development standards variance. And it's gonna be too tall, another, development standards variance. So in this case, they'll need a use variance and a development standards variance. Also, I should mention that a petitioner, and again, John and Paul have seen this, I believe, Paul, if memory serves, with Circle K, there were some 23 variance requests that night. So a petitioner is free to ask for as many variances as they need in the same meeting. They're not limited, it doesn't cost them any more, it's still $75, whatever. So it doesn't make any difference how many requests they make. But there have been occasions where someone will come to the BZA for a variance request, knowing that they're gonna come back at some later date for other variance requests. We try to get them to do it all in the same meeting, but sometimes it's not possible, and I can't recall the exact example off the top of my head, but it is possible that they may have to come back before you a couple of times for timing reasons. Now, your rules say that they can't come back for the same request. If you deny a request, they can't come back with that same request inside of a year. They'd have, that's what our rules say. If there's a significant change in circumstances, they could come back with a request, and I'm trying to think of something like, let's use the petitioner that was here tonight that was denied. Let's say if he came back and asked for a variance, a 5-foot setback variance instead of 10-foot. I'm not sure off the top of my head whether we'd permit him to come with that if that's a significant enough change, but the rules say they can't come back with the same request for 1 year. So we've had, I know Paul and John have been through that before, where we've had petitioners, I know at the Plan Commission level, I don't know about the BZA level, where a petitioner came back with changed circumstances and came before us inside of a year.
So if they keep coming back, do they have to pay those fees over and over?
If the meeting is continued, Nancy, no, but in this case, we're talking about somebody who comes back with another petition. Yes, they have to, a new application and a new fee has to be paid. I already went through the reasons for each of those variances. The lot size is too small, violates the front and rear yard setback regulations, and the building is too tall, and then the use is not listed as a permissible use in the C2 zoning district. We've gone through this, who has authority of each of the variance requests. BZA has authority over the development standards variance, and town council has the authority over the use variance request. This is an example, to try to illustrate an example of an administrative appeal. Town personnel has a temporary development sign removed from the premises at 9800 Joliet Street due to a lack of a permit for the sign. The owner disputes the removal, claiming that the sign ordinance allows the placement of such a sign without a permit. Town refuses to allow the replacement of the sign and insists that a permit must be obtained by the owner prior to putting up a new sign. The owner appeals to the BZA for help. That is an appeal of an administrative decision, so I'm pretending here that the sign ordinance is vague about that matter, but I don't know, Adam, can you think of any kinds of administrative appeals examples? This is not a real strong one. But
Well, it has, I think, I don't have much experience either, but my understanding is, what I read is that if there's some ambiguity or a gray area in the interpretation of the zoning ordinance, for example, and you probably saw an example of that tonight when we were looking at
yeah,
the side yard, requirements or the fencing allowed. And if it was determined, or if the petitioner said, or, in conversations perhaps with Rick before, and Rick said, well, you do need a variance, and the petitioner would say, well, no, I don't think I do, because this is what it says, and there's some ambiguity, that could come before the BZA for really just, how do we interpret this?
Right.
How should this ordinance be interpreted? So that would be an example of perhaps an administrative appeal.
right. They still have to go through the application, pay the fee, and do all the notice, so.
Right.
Final local authority to rule on such matters, an administrative appeal, that is the BZA. And that gets me to the end of mine.
I want to go back, and I keep thinking about what I said earlier about suggesting, or maybe if I said it, I didn't mean it when I said it, or I spoke incorrectly about the findings. I do believe that the board needs to make findings in every decision that it makes, and that it can't just rely on, again, it'll just on what the criteria are on the sheets that you have. It's, I think, important to go a bit beyond that to provide facts to support that decision. And you can enlist the staff, Rick, to assist in the preparation of those findings. So if the board ultimately determines that one or more of the findings have not been met, again, those findings can be, written findings can be submitted at a subsequent meeting. And if you were to direct Mr. Eberly to, perhaps to submit facts or support the decision of the board, I think Mr. Eberly can do that. He's, as a staff member, he can perhaps lend his insight in his review of the materials to support the decision of the Board of Zoning Appeals. And that's it. I have nothing
Okay.
further.
Well, one thing I wanted to point out to you, as I said, you have a copy of the rules and regulations here, and on page 7, really, this must be double-sided. Yeah, I'm sorry, yeah, it's double-sided. It didn't. On page 7, the first paragraph talks about the regular meetings being held on the 4th Monday of each month at 7 p.m. Next month, that changes. So it becomes the 3rd Monday of the month, effective in March, and we do have a petitioner for next month's meeting. That would have changed, it was gonna change this year anyway to the 3rd Monday, but I was gonna be out of town the 3rd Monday of January, and the 3rd Monday this month was President's Day, and we're closed on that day, so, starting next month and going forward, it will be the 3rd Monday of the month at 7 p.m. in this room. Yeah, at some point in time, whenever we amend the rules next, we can, I don't think it's important that we amend them right away, but that is a change. I mean, I wouldn't amend them just for that. I don't know how you feel about that, Adam, but,
Well, it would be simple to do. I think it would be, I think we should. I think if we're
Okay.
gonna change it, it makes sense to go ahead and take some formal action.
okay, we can do that at the next meeting?
Yeah, I think we can do that next
Okay,
week.
let me make a note of that.
Adam, what is the, if a petitioner is not satisfied with the decision or development standard, what is the option to a petitioner?
If they,
They did not like the decision.
Wanna contest it?
Is there any course of action?
Yes.
the petitioner-
yeah, no, that's, basically, they could seek, judicial review.
Okay.
Yeah, I mean, if they feel that the, decision was egregious or not supported by the facts, if the petitioner feels that they met the criteria and the board acted arbitrarily in denying the request for the variance, they could seek review, of that decision in a court. And then the court will, as part of that process, look to the record. What are the findings of fact? What was the determination made by the board? It'll look at the meeting minutes that would be examined, so that would all be part of the consideration in any kind of review process.
Rick, anything else for the training?
That's all I have. Question?
So in St. John, we have all kind of HOAs.
Mm-hmm.
I think even told Penny that we have some kind of agreement that you agree to when you buy a lot. So when you get a petitioner, do you have to look at the HOA first before?
Great question, Nancy. I appreciate you asking that. If we're aware of there being an HOA, then we advise a petitioner, anybody who comes in for a building permit, we say, check with your HOA, make sure you get their approval before you come to us. Now, having said that, we don't enforce covenants of a development. So if you live in an HOA that does not allow sheds, for example, but we do, then I'll grant you, in fact, I think I have to grant you a permit if you apply for a permit for a shed in your subdivision. I will advise you, if I know of it, that your HOA doesn't allow it and you're gonna have a fight with your HOA, but I'll grant you the permit. The only one, and this is something that Adam and I have not had a chance to talk about this at all, but because of our agreement, some agreement we have with the gates, I'm told that we are required to live by the conditions of their covenants. So if the gates says you can't have a shed, then I can't issue a permit for a shed in the gates. Now, that's what I've been advised by previous municipal attorneys here. Adam and I have not had a chance to talk about that at all, but it has to do with the annexation agreement and that we are tied to their covenants specifically. But in any other development, we will advise people, get that approval first and then bring it to us. But if I've had, I think, one instance where an HOA seemed to be stonewalling the petitioner for some reason, and it was a fence, if I recall accurately. And it was proper by our standards, and it wasn't the gate, so I granted the permit, without ever hearing from the HOA. But we don't grant, if your HOA says you can have a shed, but it can't be more than 100 square feet, and town ordinance will let you go to 160, we'll let you go to 160. We won't grant you a variance from the HOA standards, because we simply don't recognize them. We have 1,700, close to 1,700 ordinances that we've adopted here to date, or from the beginning of time to now. And we got enough to do with enforcing and knowing about our own regulations, the individual covenants. Yeah, but that's a great question.
Mr. Chairman, I'd like to mention one more thing about the rules and regulations, just an idea. We had discussed before on both Plan Commission and BZA, perhaps changing the number of days' notice to mirror state statute. Currently the BZA is required 15 days. State statute only requires 10. So the problem is, we're requiring more than state statute, and I've been sitting in that chair and had a petitioner come up and said, well, we missed it by a day, so we did 14 days, which is still 4 more than state statute. We've overachieved, but we just didn't meet the town rules, and we've, sometimes granted waivers and then been criticized for it, even though we're still overachieving actual law. It's confusing to the public. So it might be easier to just mirror state statute. It's 10 days, and it's got to be 10 days, and if it's not, it's not. We can't hear it. So that's something that we had kicked around before. It's something you may want to consider. It would just take some of the pressure off of you. It would also expedite the process for a petitioner. They could get in here a little quicker without, 5 days less burden on them. So I'm not sure if Mr. Eberly has any opinion on that.
Yeah. The reason we went to that in the first place is because oftentimes, if you've ever done this before, the mailings that get sent out are sent out with a return receipt requested, and that's the green card that comes back to my office. And what they get is, one of these goes out with each mailing, what I call the white receipt, and this is the green card that comes back to the petitioner who sends the letters out. These will trickle in sometimes beyond the date of the meeting even. These are what's important, because this tells me, it's got a date stamped on it, and this tells me when the petitioner made the mailing effort. But in order to try to get more of these back, we extended that date, that notice from 10 days to 15 days. The other thing was, sometimes the proofs of publication from the newspapers take a while to get back, and sometimes they're not back before the meeting. So in those cases, a petitioner would have to be able to show me a copy of the ad from the actual newspaper, so I can verify that the date that the ad was placed. Now, I'm not gonna say that happens all the time. I don't even know if I could say it happened more than 10% of the time, but I know that there's been times where these don't come back, or the proofs of publication don't come back if you're only giving a 10-day notice. But again, they can give me some other proof of the notice, and they can give me, these are what's most important to me anyway. If I never get any of these back, I'm not as concerned, because this proves that they made the effort. Once they've given it to the post office, it's out of their hands. So I don't have a lot of heartburn with that, because Paul's right. We've had a couple of 2-3 instances where we've been asked to waive the 15-day requirement, and we've been accused of violating state statute. Well, we didn't. We gave a waiver to, we can't waive the 10-day requirement. That is a state statute. But we waived the 15-day requirement when there's been an issue like that. And I can probably think of 3 or 4 times when that's happened since I've been here. So I don't have a lot of heartburn with that. The other thing I requested, and I still feel this way, I don't think we should require publication in 2 newspapers. I don't think anybody gets the information from the newspapers in the first place, and you're spending $150 or more with each newspaper to put the notice in the paper. And we're making them do it in 2 newspapers, and I will almost guarantee you that 99% of the people don't get the information from that legal notice that appears in the Times or the Post-Tribune. I think the law requires 1 publication in a newspaper.
Correct.
We require 2. So I've always been an advocate of following state law and going with 1 as opposed to 2. I just think it's a hardship on any petitioner, particularly a resident. It's not as big a deal for a commercial property owner, but I think it is for a residential property owner. So just something to consider. When we brought this up before and revised the rules and regulations of both the Plan Commission and BZA, the members at the time felt that in the interest of transparency, it was better to have them go ahead and put the notices in 2 newspapers. But I disagree, because I just don't think people get their information that way.
Well, just some things for the board members to think of, and maybe we could discuss a little bit at our next meeting.
You asked about a website. What'd you ask?
I'm just saying, do we post public hearings notices on our website, so
We
if
post the agendas on our website,
But,
but not the actual notice of public hearing, no.
Okay. And then, so Rick, I guess the question, going back to Paul's real quick about the 15 to 10 days, I would just like to make sure the procedure from that 10 days, we can meet all, like you said, you gotta, as long as you feel comfortable with the process and procedures, that all the documentation you get back in time, because I don't want it squeezed where all of a sudden we don't know if all the mailings have been out, the notifications out in the paper. That would just be something I want to have a better comfort level on.
Right.
That
And-
everything downstream from the notification is in a timely manner.
Right.
And we have enough
And
time
that's
that we're
another
not
re-
scrambling an hour before the meeting going.
Right.
Did everything get out on time?
And that's another reason for it, John, because our rules require them to provide this proof up to me 7 days in advance of the meeting. And if they only have to get it out 10 days in advance, they're certainly not gonna have the green cards back 7 days in advance. That's not gonna happen. They're gonna have the mailings, the day they mail those, they'll have those white receipts. But the proofs of publication won't be back 7 days prior if they're only having to send the notices out 10 days prior. So we may have to change that time period in our rules too, and not require a 7-day submittal to my office. It doesn't typically take that long to go through the information anyway, but you do want to give me some time. I might be busy, I might be on vacation, I might, who knows? So you try to get it in, but they won't meet the 7-day submittal to me if they only have to meet 10-day notice requirement.
So maybe for the next meeting, we could just maybe get a comfort level on how many days, because,
Bless you.
I mean, sometimes our expectation is we, exceed state statute, and it puts us in a better position to have everything in order and in line.
And we're talking calendar days here, not working days.
Understand.
So, if we wanted to go to 10 days and reduce their submittal to me to 5 days or 4 days or something, I guess we could do that. But keep in mind that we're doing our meeting on a Monday, so that means I'm getting it Thursday
Yeah.
before.
Okay.
That can be problematic, that
So maybe we
submittal
just
to my
backtrack
office.
from your notification and see what we feel comfortable with.
Yeah,
Okay.
yeah,
That's something to think about.
yeah.
All right. If we're done with the training session, I'm gonna open up for public comment. Mr. DeVito, do you have any comment?
I just appreciate the opportunity to participate.
Thank you very much, sir. Thanks for being here tonight.
You're a trooper, sir.
There you go.
Any comments from the board?
Mr. Chairman, if I may, I just wanted to thank all of you for, again, stepping up into your roles, volunteering for this position. It doesn't pay a penny. You'll take a lot of criticism through the year at times. So I appreciate you taking a Monday night, being here to get trained up, understand the process, and being here every month to help get the business done in town. Definitely appreciate it. Thank you.
Thank you, Councilman Panzik. With that, we're adjourned.